Hello and welcome to our series of Target Prelims 2019. Coming to the first topic of discussion, Insolvency and Bankruptcy Code. Now, if you're following my videos for the mains, there you must have seen that in one video I had suggested that I will soon be picking up this topic of Insolvency and Bankruptcy Code. This is a very important topic for prelims this year. It has continuously been in use, so a question can be expected. In the month of June, however, in the month of June 2018, this was in news because an ordinance regarding amendments to the Insolvency and Bankruptcy Code is what has been promulgated. So that is what makes this entire code important. Now, first thing that is important here is the meaning of insolvency, bankruptcy, and the word code. Now, insolvency is basically a situation where a person is unable to pay his bills up to the due date. Now, when this situation is something that is officially declared, then that is the situation of bankruptcy. So there is a thin line between insolvency and bankruptcy. Now, why is it known as a code is because this particular law, it's not known as a law, it is known as a code because this was a single law which consumed several other laws which were existing for executing the insolvency and bankruptcy resolution process. So because this is an amalgamation of a large number of laws within it, it is not called a law, rather a code. The second thing that is important is with regards to some salient features of this particular code. In the salient features, the first point that is important is that it creates a time-bound process for insolvency resolution of companies and individuals. So what is important here is that both companies and individuals are included within this code. This is a question that has been asked in the past in several state services exams. Also, next, what is important is that the process is to be completed within a time frame of 180 days, and this is something that can be extended to 270 days. So this time period is what is important. Next, what is important is the resolution process will be conducted by licensed insolvency professionals. So this is a new thing that has been developed, that are new specifically trained professionals who are known as the insolvency professionals. And also what is important is that these professionals will be the members of insolvency professional agencies. So this is something that is important, that an insolvency professional agency is what is formed. This insolvency professional agency is going to train some professionals who will be known as the insolvency professionals. So this is something that is important and a question can be asked in this regard. Next, what is important is a new body, that is the information utilities. These have been established to collect, collate and disseminate financial information to facilitate the insolvency resolution. So this is something that is new, and as a result of which this becomes important. Next, what is very important is the adjudication process under the Insolvency and Bankruptcy Code. Now, there are two means of adjudication. The first is under the National Company Law Tribunal. This is for the adjudication vis-a-vis companies. This is one difference between these two adjudicatory bodies. And the second is the Debt Recovery Tribunal. So this is something that is very important, that the NCLT will deal with adjudication of companies, whereas the Debt Recovery Tribunals will deal with adjudication of insolvency and bankruptcy of individuals. So this is the difference between them. Also, you should know that the National Company Law Appellate Tribunal is something also that has been formed here, which is important because the appeal from the decision that is going to be taken by the NCLT is going to go to the Appellate Tribunal, and from here it is going to directly go to the Supreme Court and not to the High Court. So this is another question that can be asked in this regard. Next, what is very important is the Insolvency and Bankruptcy Board of India. This is the regulatory body which will regulate the functioning of the insolvency professionals, the insolvency professional agencies, and the information utilities. So this is one thing that is important vis-a-vis this. You should know that the Insolvency and the Bankruptcy Board of India will have no control on adjudication. So this is only a regulatory function and not a adjudicatory role. A question is sometimes framed that the IBBI will also have a role in adjudication. So no, it has no role in adjudication. This is something that is important. Next, what is important is that even cross-border insolvency is what is under the provisions of Insolvency and Bankruptcy Code. Often it is thought that it is limited to transactions within India, but that is not the case. In many times, what is seen is that insolvency has cross-border perspectives associated with that. So cross-border insolvency is also under this particular code. This can be a question in itself. Next, what is important is a revision aspect. The institutional infrastructure has 4 pillars. The first is insolvency professionals, as we've discussed. Then is the information utilities that are being formed. Then it is the adjudication, which includes the National Company Law Tribunal and the Debt Recovery Tribunal, and the regulation, which we know is the Insolvency and Bankruptcy Board of India. So this is something that is important. Now, as I told you that there was an ordinance which was formed. You should know some salient features of the decisions that were taken in this particular ordinance, though the amendments that have been introduced to the code, though they are not of much importance, but still some aspects are what become important. So first and foremost, you should know that if in a real estate there are home buyers who are involved in a company that has gone bankrupt, then the home buyers would be treated as financial creditors, and they will have the right to be represented in the committee of creditors. Now what happens in this under this code is that a committee of creditors is what is formed, and this committee of creditors is actually deciding through its votes that whether or not it should be the adjudication process should be allowed to be extended beyond the limit of 180 days. So such kind of decisions are what this committee is taking. So this is committee is also something that is important, and now to this committee home buyers are also added. So that is one change that has been made. Also under the amendment, the related parties will not be allowed for bidding of the liquidation of a particular company. Suppose a company is declared as bankrupt and it has been adjudicated as bankrupt, and the liquidation is what is happening, then there is going to be bidding of selling of its assets. Now in the bidding process, the related parties cannot participate. So this is some changes that have been brought. Some changes have been brought in the share of the votes of this committee. For instance, previously for deciding upon the extension process, 75% of the votes was what was required. Now this has been reduced to 66%. So these are small changes which have been introduced. These are not something that UPSC is going to ask, but UPSC will definitely have an option to check the knowledge about this code, and that is the basic aspect which UPSC will focus on. So that is why I have discussed and focused upon that aspect more. So that's all about this discussion. Coming to the next topic that we shall be discussing today, it is about the Asian Infrastructure and Investment Bank. Now this was in news because the third annual meeting of this bank is what was held in Mumbai in June. So that is why I have picked up this conventional topic for discussion. The first thing that you should know is that this is a multilateral development bank that is aimed at building infrastructure in the Asia Pacific region. So this is one question, that it is focused on which region? Asia Pacific region. Oceania region is also included under this particular bank. Another thing that is important is the date of formation. The bank was basically formed in December 2015, but actually it came into its functioning actually started from January 16, 2016. So that is something that you should know. The confusion can be between these dates. So that is why please be careful. Next, what is important is with regards to the headquarters. It has its headquarters in Beijing in China. It has a membership of 70 countries. 70 countries are the members of this particular bank. And this is important because India holds about 8.99% stake and 7.5% voting rights, thus making it the second largest shareholder after China, which has a stake of 32%. So this is something that is important, and this is what makes this bank very, very important for India. Also, you should know that this bank will be investing in India's infrastructure and investment funds. That is the National Infrastructure and Investment Fund of India is getting its funding from this Asian Infrastructure and Investment Bank. So this can be a question in itself. Also about the third annual meeting that took place in Mumbai, there was a fund that was declared, which is the Asian Infrastructure Fund is what was launched. So this is one newer development which has happened vis-a-vis this particular bank. Another thing is that this funding is largely going to focus on something called green finance, which means that financing will be done of infrastructure or for that matter investments where the considerations of environmental protection is what is being maintained. For example, solar power plants are going to be funded on priority. So these are some aspects of the funding, and the bank is indeed a static portion of the current affairs, and it can be asked any day in the prelim. So that is why it is important. So that's all for today's discussion. I thank you all for watching the video.